for the record, when the court gave us that information at the last arraignment, I spoke to my director about it, Jerry Word, and he didn't believe that there was a conflict, and I don't believe that there's a conflict with the way the council was reorganized, so we're not going to raise that as an objection.
Thank you. Mr. Costello, nothing from the state. All right, thank you. And let's see, Mr. Gardner, I believe you're a first chair qualified, is that right?
That's correct, Your Honor. And I can just go down the list if you want.
That would be good.
Thank you. Your Honor, I've been a member in good standing with State Bar of Georgia since the year 2000. I've been lead or co-counsel in more than 20 death penalty cases, including cases trial to verdict. I am familiar with the Unified Appeal Procedure, and I am familiar with and experienced in the use of expert witnesses, and I have received the specialized training required for lawyers in death penalty cases within the past 12 months. And the last one, I leave it up to the court to determine whether I'm a good lawyer or not.
Okay, and second chair, your qualification?
Judge, I have been a member in good standing with the State Bar of Georgia since 2003. I have been either lead or co-counsel in numerous murder cases, including approximately 17 death penalty cases, including cases that were tried to verdict, sentencing-based verdict.
Right.
I also have attended, within the last 12 months, at least 10 hours of specialized training and will continue to do so during the pendency of this case.
And I don't believe this is required of my prosecutor. He's elected by the citizens of Henry County, so that makes him qualified. All right. Okay, it says I have to basically, after being provided with a copy of your Unified Appeal Procedure, which, by the way, is still available on the website, it's in there, all you need to be instructed to read and adhere to the provisions of the Unified Appeal Procedure. I don't think it's necessary in this case, but it always says I got to do it, I do it.
Yes, sir.
Court reporter has been given a copy also. That it needs to be on the record. She was given one at the time, about March 31st, I believe. All right, the reporter is reminded that everything shall be completely transcribed as set forth, and it says Rule 4A. I think that's still the rule.
Yes, Judge, and just to perfect the record, I believe that date when we last convened was March 21st.
21st.
I may have misspoke.
I'm sorry, I misspoke.
March 21st, 2017.
That is correct. Thank you. All right, I have to instruct defense counsel. I'm sure y'all get tired of hearing this, but you have to be instructed that the outline and checklist are intended to assist you in protecting the defendant's rights, but it remains your responsibility as defense counsel to protect those rights. The outline and checklist do not take the place of diligent counsel actively representing the defendant. Also, you shall be reminded of the defendant's option to invoke provisions of Georgia Criminal Procedure Discovery Act, OCGA Section 17-6-1 ETSEQ. If the defendant elects to participate in reciprocal discovery, both parties shall be reminded that the information provided shall be accurate and complete and updated as required by statute. The court shall determine whether the defendant intends to challenge the array of the grand jury or the traverse jury. Is there any at this time?
We do intend to challenge it, Your Honor, but we haven't filed any motions yet.
All right. Let me do this. And of the traverse jury?
Yes, sir.
All right. Okay, we're supposed to do both of those. Well, actually, we can't really do much about the traverse jury. We can do something about the grand jury. We need to do that at the earliest possible time. That's as soon as you get an opportunity to get your motions filed, we will be scheduling. And in that regard, I'm going to step out of this process just a second. when I found out y'all were going to be involved, I thought it might be beneficial for you to get to court you don't have to provide it to anybody else, but and Mr. Patilla may be interested only, but for scheduling purposes, since we are in this state by rule, oldest case to the newest case is going to take precedence. It might be helpful for the court to know your list of your cases that you're currently involved in, and that way we have to work around them, and we'll be able to sort of lay a groundwork for how we're going to get to where this ultimately comes to a conclusion in some form or the other, unless something along the way trips it up. And if I know how many cases you have ahead of us and what is scheduled in those cases, you don't have to go into great detail, just, motions, hearing, or whatever. It might be beneficial for us when we're planning to know what's going on.
Yes,
so if that's not too much trouble, I would appreciate it.
No, sir. We actually have lists prepared that we can provide to the court by tomorrow.
Okay, that'll be great. Thank you. I will give you an address that will be available to send us copies, so you will not have to mail. You can mail copies if you want, but we prefer to get them to the Chamber's address, and that address is McGarrity Chambers at co.henry.ga.us. And you will be put in there as a preferred sender, so that your stuff will come through.
Thank you.
And Mr. Patilla has already made it on that list. As the fact that he's the DA in the county, he got on it. So anything you send will be accepted and won't be kicked back to you. Okay. Since there is going to be a challenge, paragraph 6 really doesn't apply, so we'll deal with that during the hearing. Okay. We have reached the juncture of Mr. Kosky. I am on issue number 7, which basically I'm required to ask you at this juncture of the case if you have any objections to defense counsel or to the manner in which defense counsel has conducted or are conducting your defense. I don't know why they think anybody that's not trained in the law would know, but you're supposed to express your objection if you have any. If they haven't talked to you.
They're awesome. They're great.
All right, well, that's
Perfect.
good to hear. Good to hear. The court will review part 1 of the checklist with defense counsel and the prosecuting attorney to determine which pretrial issue the defendant intends to raise, and then we'll start scheduling hearings once we know what they are and how much time we need. All right. The pretrial checklist, we will go over that. That's on page 14. We have the arrest issues. It may be kind of premature, but I'm not sure how deeply into the case you've gotten. But
I was going to bring that to the court's attention. We have not received discovery, and generally we don't at this stage, and I normally tell the court we intend to raise any issue that we find within the case. So we have provided Mr. Kosky a copy of the Unified Appeal so that he could go over it. We have talked to him about some of the aspects of this case. So I guess as far as the court is comfortable, I can make this representation that we have reviewed the checklist and that we do intend to raise every issue that we find after a thorough review of the discovery.
all right, I think that will be sufficient.
Thank you.
And just so that the court knows, Your Honor, the defense has filed today a motion for discovery, which we have been served with, and the state of Georgia is prepared to serve them with discovery today in court. We're going to hand serve them as well as their client today before we leave.
All right. Well, we'll get it to your attorneys and they'll make sure you get everything you need, okay? If you have the checklist in hand, let's look at page 16 and the issue on subsection J, top of the page on mine. you've already interested in making a motion in that regard, I thought maybe we ought to encourage you to do that first.
Yes, Your Honor, and what I can say to the court in open court is that that will be an issue in this case. And there are issues that some have brought to the district attorney's attention, and we will bring issues to the court's attention. And if the court wants more information, we can provide more information in the ex parte context, but that will be an issue in this case, Your Honor.
Well, my reason for emphasizing this is that it should be the first motion that gets filed shortly, besides the challenge to the grand jury. Simply because depending on which motion it is, if it's both of those issues, then we have complicating factors about going forward without that information.
That's correct, Your Honor. And for the court's information, at this point, we don't have information with respect to number 2 that we would believe would be something that could stop this process, but we are aware that Mr. Kosky was a participant in the Henry County Resource Court, and that he was also a participant in the Integrated Treatment Program through the Department of Corrections. And so we're trying to get those records so that we can bring paint a more complete picture for the court and for the state.
All right. So I just sort of emphasize that section of the pretrial checklist. I think that would be sufficient to cover all the other items that you had mentioned. I have to instruct the defense counsel to locate and interview all persons whose testimony might be helpful in discovering or supporting available theories of defense or in mitigation of punishment. I'm sure you're not unaware of that. I just put it on the record. And let's see. Well, I think we've pretty much got, at subsection 10 is, of course, the schedule and appropriate time on arraignment and plea on the merits of the indictment.
If the court wants to proceed today, we can. With respect to that, we have provided a copy of the indictment to Mr. Kosky and have gone over that with him.
Well, we can do that. Mr. Patillo, do you have that?
I have the original indictment. I'm handing it now to Mr. Carter.
Yeah, for the record, we have signed the indictment, and Mr. Kosky has signed it also. And Your Honor, I don't know the court's procedure with this, but to the extent that we can, we'll waive formal reading of the indictment.
That is, you can, and you are appreciated doing it. I have only had one formal arraignment, I think, in the last 10 years, and it's not that complicated, it's just a lot of reading.
That's correct.
In these type cases, as you're well aware, it's always best to err on the side of caution. And if any time somebody says, we never did a formal arraignment, I'll be glad to set it all aside and start all over. I have no problem with that. Okay, the not guilty plea has been entered. I think it'd be a good time, Mr. Gardner, to say, I finished the checklist essentially. Is there anything else that you would like to take up today? The only thing that we can ever talk about is scheduling.
That's
So everything else has to be done in Mr. Kosky's presence, and I want you to be aware of that, Mr. Kosky. There's nothing going to be taken done in this court without you being present.
Appreciate it.
There's one issue that we'll bring to the court's attention now, and we're trying to work through it. Apparently, the jail has a policy between 10 o'clock and 1 o'clock. They don't allow visits at the jail. Each time that has been an issue, we've been able to speak to someone to resolve it. But I just want to let the court know that we will speak with the jail staff, the appropriate person at the jail about that. And if we can't resolve it, that's an issue that we will bring to the court. My understanding from speaking to the district attorney is that the discovery is 61 DVDs and 8 32-gigabyte thumb drives. So 4 hours out of the day that you can't sit down with your client in the middle of the day will become an issue if we can't get that resolved.
I don't think it's difficult to guess why that is, but that is probably a rule that's more applicable to the average jail population and the running of the jail. I will give you a name.
Yes, sir.
And this is your contact is at the sheriff's office. He may designate someone else, but this is the chief deputy, David Foster.
Okay.
If you'll contact him and tell him that I have given you his name, he's at the sheriff's office phone number, to coordinate your times and your office staff time, whoever's going to be there, give them the names of any and everybody that might want to be there, that's allowed to be there, and coordinate. He will either coordinate it himself or he will give you a point of contact, someone else.
Yes, sir.
And there will obviously times when some of these staff have to be in training, some of them have to be, so they should designate someone to take their spot when they're away from the sheriff's office and for any length of time. But Mr. Foster has been, used to work here in the courthouse, and he's been promoted up the ladder of success, and he is the chief deputy out there. Has always done what I've asked him to do, and done it well. And if he needs to be, if he's not the person, he will designate someone else. And it may be someone with the jail that's ahead of the jail. And I'm not sure who he wants to burden with that or reward with that, whichever the case may be.
Okay.
Thank you, Your Honor.
All right.
And that completes.
Mr. Patillo?
Yes, Judge, with the court's permission, I would like to go ahead and serve Mr. Kosky and his attorneys with the discovery that we have. It is, in fact, 61 CDs, and one of the CDs contains the entire police file, which is about 928 pages. And we also have 8 flash drives to provide to them today. I'm going to do that. We filed our certificate of service this morning in the court. I'm going to hand it to Mr. Gardner here. And he has been officially served with the discovery.
All right.
And obviously, and I've told Mr. Gardner this, as other discovery becomes available, we will make that available to him. We have a continuing open discovery policy for this case in our office, as we do with all cases. And they have all access to our file at any time they want to make an appointment and come and inspect the file. So we made that clear to them. I want to make sure that's on the record.
All right. And our clerk of court is Barbara Harrison. I think we had a death penalty case in Judge Amero's courtroom not long ago, so she's familiar with challenges to the array of the grand jury and traverse jury. So at such juncture as that occurs, she will be your contact for that information. She will provide everything she has, and whatever you can provide that to your experts or such that you may need. For me in my office, Your point of contact will be Vanessa Eccles. She has been my law clerk for 13 years.
Maybe.
13, somewhere in there. Started out as a 2-year stint, and she liked it so much she couldn't leave, or something like that. I will let her give you her contact. Rather than me giving an email address, she'll give you one. You might even want to set one up dedicated to these cases.
I may, but generally come into McGarity Chambers. If I need to set up a separate
Okay.
one, I'll get in contact with each of you and let you know. But right now, McGarity Chambers is good.
Okay.
And I'll also provide my direct dial without making an announcement in court. So I'll also let you all have that too.
And, Your Honor, I'm going to provide her with my card
Sure.
when this is over and my cell phone number because we're rarely in the office.
Yes, I suspect that's the case. As far as setting motions hearing, it's too early for us to do that. You've got some discovery to get through.
Yes, sir.
And I know, I haven't seen your list, but I know you have some cases that are higher, older cases than this. And so when we start scheduling, if there's any leave of absence, I'm going to be fly-specking those.
Yes, sir.
I have one particular lawyer who likes to jump out of airplanes a lot. Yeah, he's been doing high skydiving for years, and he goes to all these competitions. And I have to hold him back because he wants to jump every other week, and I want him to come to court every other week. So we have a hard time getting him. So we'll fly-spec your leaves, and if there's any of them that I deny that you need to specifically go on, just let us know and we can work around it. I'm sure you don't have many opportunities to take leave anyway in your job.
No, sir. No, we don't. And, Your Honor, we can tell the court right now, we know we have a trial scheduled to start in Gwinnett County on July 31st. We expect the trial to last about 2 months. We have approached this case with an attempt to try to deal with as many issues as we can before we know we're going to be off the map. So we're going to continue to try to, as within the next month, do as much as we can with this, because at some point, probably in June, we're going to be focused full-time on that case that's about to go to trial.
So as far as where we are today, on April the 11th, 2017, you would have the remainder of this month, and sometime in May, adds about 50 days before June is upon us.
Yes, sir.
We would not be able to schedule any motions here. Just going through what you have to go through, but I think if we could do the challenge to the grand jury array, because that's one of those that,
Yes, sir.
as soon as Ms. Harrison gets you what you need, once you get the motion filed, she then gets a chance to provide what she has to. Mr. Patilla has a chance to respond. We could do that sometime in May. I know I've got a few days I'm out of office in May, and before I know I got one special set I just set up. So let's see. We have at least one full day, and I don't know how many. I've not done a death penalty case with a challenge to the array in a while. In your last experience in challenging the array, how many days did it take to actually hear it?
Well, Your Honor, this is good news. In 2012, they changed the whole process, so we're not bringing in jury commissioners anymore. It really is a pretty much automated process. The only time that we've had challenges is lasted less than a day under the new system. And, you know, there are rules that are in place, and as long as the county is following the rules, there's really not a whole lot to it now.
That's what I thought, but I wanted to see what your experience has been. I haven't actually gone through it myself. Okay, well then we will look to try to put something up in May, but I'm not going to worry about it if we don't. Except the fact when I drive in Atlanta traffic that I'm going to get from point A to point B no quicker than point A to point B can be arrived at, considering the traffic. So if I have to be somewhere in 2 hours, I'll leave in 3 hours ahead of schedule. It's just the way it works. So I don't get bent out of shape. If we can't get to it before July, we have plenty of things already keeping us occupied here in Henry County on other matters. And as I always like to conclude, Mr. Kosky, anything that has arisen today that you think you need to raise to the attention of the court?
Yeah, I do actually. How do I have 12 murders, but there's only 4 bodies.
I think counsel can explain that to you. It's sort of, they sometimes give you an example of another cases like a DUI, less safe, and a certain alcohol content. You may be driving one car one time under the influence, but they can charge you in alternative counts. So that's probably what they'll explain to you. Right now, there's no more than 4 people have passed from this event. So, and I think if they can explain that, sort of, somewhat of an explanation, they can go into more detail. All right, anything else? All right. Well, ladies and gentlemen, that will conclude the preliminary checklist from the United Appeal Procedure in Mr. Kosky's case, and we'll be back here at 2:45 for Mr. Baker's case.
Thank you, Your Honor.
All right.
The other guy here, we're just gonna, as soon as he gets down, we'll have like 15 minutes, 10 minutes.
We're going to have to wait for the lawyers anyway, we just hold him down.
Okay.
I'm sure they're separated though.
Yes, sir, of course.